topic of data protection is very important. Jokingly, we generally refer is like, you don't want your spouse to check your phone all the time. So that is, you have to protect your data. Today we have a very serious topic, and I'm very happy to have such a eminent panel. I see familiar faces. Manjaree, Apar has been on my shows on and off for the past many years, and somebody who's very well respected on this topic, regularly contributes. Sakesh, you must read the articles he writes. Google his name. There are some very interesting pieces he contributes. I look up and take points. Of course, Pavan Duggal needs no introduction. He's somebody we've looked up to for years, and others on the panel. I look forward to an interesting round of comments from these. I have a time of half an hour. 28 minutes are evening, so we'll just hit the ground running. And we will start from the round of opening comments, which will be in 2 minutes each by each of. So, the Joint Parliamentary Standing Committee of Parliament had suggested 92 amendments to this 2019 bill of the Data Protection Law Act. But now the new bill of 22 has come up. How different is the bill between what was in 19 and 22? We will discuss that in the opening comment. May I request Manjaree to start first?
Thank you, Tarun. I think it's our pleasure today to be part of the BW Legal World event, and also to be moderated by a personality like yourself. So great. Starting on the topic, yes, there is a difference between what was there in the 2019 bill, or we call it the Data Protection Bill of 2021, which got repealed, and the one that has just come out about 3 weeks ago. Fundamentally, a few differences, and I'm sure my co-panelists will add the rest. I'll just begin with a few that come to my mind. First, of course, it's simpler and leaner, as you said. The second is that it is only about digital data. So they have actually expanded on the definition of saying what is not going to be digital. So that makes it far clearer for people reading to understand that. The other important piece I felt was regarding the localization of data. I think that was a huge push from the industry, that data should not only be localized and be allowed to there should be cross-border flow of data, which has been exceeded in some manner, but of course with some very smart restrictions around it, and that also I think is a whole topic of discussion by itself. And also I think the third part is that instead of a data protection authority as was envisaged, they now have a data protection board. The fundamental difference between the two of them being that the first actually had the powers to make subordinate legislations, and it was this body seems to be only a investigating and adjudicating body. That is a big difference. The member who constitutes this board is also not very clear. A lot of it has been kept with the government by itself. And the new concept I finally felt was, one more important thing was the deemed consent concept, which has been introduced in the data protection bill this time. So, and they have outlined what would be a deemed consent. So some of the few changes.
Thanks for that opening comment. I'll go to Karnika Seth for her opening comment. Over to you, Karnika.
Thank you, Tarun. Indeed, if you look at the PDP bill, which was the earlier version, and now the new PDP bill, there is a vast change not only in the number of sections we have, it has certainly bridged the gap. I mean, I would say brought it to a very concise draft. At the same time, the language is easy. However, there are certain points that I'd like to just touch on. One is that the number of quantum of punishments, they're definitely very, very high in the current proposed version, because it's running up to about 500 crores, which is a huge amount. What we saw earlier, in the earlier version, it was maximum up to 15 crores or 4% of global turnover. And now the industry does understand, I mean, if this gets into an enactment, then there are huge stakes involved for any kind of data breaches. Then when we see the personal data, the word personal data, now it involves in the new version not only the data which is collected digitally, but also that data which is collected offline, but is digitized later. So personal data is defined like that. And in the earlier version, we were also, when it was brought before the Joint Parliamentary Committee, there were debates also on having non-personal data also, alongside. So that's something we haven't seen that in the new version, strictly personal data. It does away with critical sensitive data or sensitive data, those kind of terminologies defined, and collates entire personal data into one category. Now that has to be seen whether will that be enough to protect any kind of sensitive data like Aadhaar, for instance, or health records or other kind of financial data, because there isn't any delocalization mentioned in this version of PDP, as well as no mirror imaging needed, and the standards to send it transporter, those have to be defined by the government. So when we say whether it will meet the adequacy requirement, reasonable security practices and adequacy of PDP, like something on a similar line in a different jurisdiction or not. Like in US, we have a privacy shield. So do we have those prescribed criteria? What would be those prescribed criteria, and which will be those jurisdiction is yet to be seen. So that is also a very, very important change. And thirdly, if we see Section 43A of the IT Act, we currently have a duty by the body corporates to preserve or collect data and preserve data in such a manner that it safeguards its security. So that section will be done away with in the new version. Now, if that happens, how does a person who has a grievance against a body corporate for its lapse or negligence, how does he seek compensation? Because the new version talks about even voluntary undertaking given by an entity, so that there would be no legal redressal left, to pursue thereafter. So those are some questions we're all debating on at this point. There's a lot to talk.
Yes,
I'm sure
but
we'll be all
thanks for
discussing.
that opening comment. I'll go to Apar Gupta for his opening intervention.
Thanks, Tarun. Just to refresh, the question you asked was what's different in the Digital Personal Data Protection Bill, which is put up for public consultation, and all of you can send comments to the government till December 17th. So I do encourage you to participate in this process, right? This kind of inputs would possibly help the government make a better law. Now, the significant deviation is that in the Shri Krishna committee, the report accompanied a draft bill, which was then put through a process by the Ministry of Electronics and IT, which is the central government ministry, and which then introduced that law in Parliament. And then a JPC considered it, it gave its recommendations, and also redrafted the law, right? And when you look at that law, it emerges from the context of the Supreme Court judgment. The baseline is not the Shri Krishna committee. The baseline is the Puttaswamy judgment in August 2017. And if you read the decision by Justice Chandrachud, which is signed by the 4 judges, I think so, which is the highest numerical value, and read it with Sanjay Kishan Kaul's judgment, there are certain principles which are prescribed in the Puttaswamy judgment which make express, and I will repeat this, express reference to the central government to make a data protection law. There are certain standards given, such as legality, necessity, proportionality, and safeguards, which should be there. And Justice Shri Krishna takes this judgment as an underlying framework and then proposes a data protection law. Now, that's been done away with, okay? So you cannot by itself compare significant architectural choices which are now placed in the Digital Personal Data Protection Bill. In some ways it's new, in some ways there's similarity. For instance, consent is still the bedrock of framework of how a data fiduciary gets data from a data principal. Data fiduciary being a person who gathers your data. Data principal being you by itself, right? But what is significant is, and several lawyers found this refreshing, is that this law is very simply written. It contains only 30 clauses. And we look at the Sri Krishna version, it is bounding to about 94, right? Something like that, right? So how has this been achieved? There's a setting in Word which is called auto-summarize, right? And quite often you omit detail, right? When you essentially abbreviate or edit any document, right? So that detail is absent here. And in any statutory framework, when certain core ingredients of a law are not there, what is it filled by? Subordinate legislation, a rulemaking power. Who is that rulemaking power in favor of? So the phrase "as may be prescribed" is mentioned 18 times across these 30 clauses, and it's in favor of the central government to make these rules. However, and I think I've written about it, it's called the cost of brevity, and this is an op-ed in the Indian Express. You can go and check this reasoning, which I've developed there, is that it's without core anchoring legislative criteria, which is there in the Puttaswamy judgment. So I think there's a lot to be achieved. I'll comment further on the other issues in this bill, such as the absence of a regulatory body, it not having independence, too much power with the central government, and this becomes important because the data protection law does not only apply to corporate entities, but also to public officials and government entities as well.
Thanks for that opening comment, Apar. I'll go to Rajul Bohra for her comment.
Hi everyone. So there has been a lot that's been spoken about by my panelists on what has changed. But to be honest, if somebody asks me, would you prefer a law that is detailed versus a law that just gives an outline? As a lawyer, I would say I would need a detailed law. And in fact, why not just as a lawyer, but even as a citizen of the country, I would need complete guidance by the lawmakers and not by the government who will implement such law. So that is one biggish issue that we see in this. The second is regarding this concept of deemed consent and exemption requirements that have been introduced. Now what the new bill says is that the government will have the discretion to have its own agencies being exempted by the requirements of the bill, which means that government can use various reasons such as security, sovereignty, integrity, public interest, some law being contravened, and hence get its own bodies out of the entire regulation of the law. And what is important and what's interesting here to see is that government is the biggest data fiduciary that we really see, because a lot of our data lies there. So exemption, it's a big question mark. Second, the deemed consent, which says that such consent which would have ordinarily been given by someone where, for employment purposes, for fraud purposes, for M&A purposes, that should be deemed to have been given. Now that's a new concept that we've seen under the new bill, which was not there in the last one. One more important topic that I would like to touch upon is the entire consent revolving around children. It's very interesting to see that, you know, in this era, industrial revolution 4.0 that we are talking about, which is actually in the hands of children, much more than people who are, who are us, right? And therefore, what we've actually seen is that in this category, the definition of harm, which said that there should be a consent given by the guardian, and now the new bill says that it should be a verifiable deemed consent that should be given. Now what is verifiable? Again, it's not clear. Second, it says that there should be no harm done to children when you are using their data. Now the definition of harm again has been shortened. It was a detailed definition under the earlier bill. Now it just says that you can't do behavioral monitoring of children, and you can't have, and so basically that entire purpose has also been shortened. Then what is more interesting is to see the Data Protection Authority versus Data Protection Board. In fact, the entire composition requirements, appointment of these judges who will be there in the Data Protection Board, that has all been left to the government. And most importantly, the new bill says that the data principals, which means we as data owners, will also be liable for penalty. Which is one of the first times in the history of the world where it has come that the data protection bill is imposing penalty on the data principals. And the requirement that is applicable to data principals is that they should not give any consent which is the wrong consent. So it should be a genuine information that they give at the time when they are giving consents or data. That is obviously a very onerous requirement on data principals, I would say.
Thank you, Rajul. Over to Dr. Pavan Duggal for his opening comment.
After all my panelists, I just want to add 2 points. First, this draft law is a classical case of 1 step forward, 3 steps backwards. It's a law that's completely bereft of existing ground realities. Today, you cannot talk of data protection without cybersecurity. The law is silent on all parameters of cybersecurity, proposed law. Further, they scrap away Section 43A, which mandates all intermediaries to have in place reasonable security practices and procedures while they are dealing, handling, or processing sensitive personal data. And ISO 27001 is one such example of reasonable security practices. So effectively, the law is saying, I'm fine, don't follow ISO 27001, just follow with my broad principles, I'm good. I think it's a recipe for disaster that we are waiting to unwind as we go forward. That's one. Number two, this entire new legislation, if it comes up in the current form, is going to do far more detriment and damage to Indian cyber sovereignty than any other law put together. Why? Because for the first time, the government is taking a complete U-turn. I go back to 2018, the RBI says banking data of Indians has to be within India. Thanks to its stubbornness, yes, banking data of Indians remains in India. Come the Personal Data Protection Bill 2019, and they say, well, data localization is slightly watered down, but still it's still there. Come this new PDP or DPDP Bill 2022, and data localization is completely given the go-by. Now, remember the scenario, by the end of next year, we are going to become the most populous nation in the world. We'll be the biggest generators of data across the world, including the biggest generators of personal data, personally identifiable data, sensitive personal data. And if we are going to allow all of that to go out of India in some jurisdiction that the government says is okay, then I think we are ultimately doing a homework which is wrong on its fundamental principles from the word go. Look, you have to quickly realize once data gone, it's gone forever. Let's take the recent AIMS ransomware attack. 4 crore Indians, sensitive personal data, health data, gone, including former prime ministers, former ministers, politicians, judges, bureaucrats, and the like. And that data is still available today afternoon for sale on the darknet. Imagine the kind of ramifications it's going to have upon all those people who could potentially be made a victim of cybercrime. So I think this new legislation is completely bereft of existing ground realities, that the golden age of cybercrime has begun, when cybersecurity breaches are paramount and cyber attacks are the de facto norm of the day. You cannot now come up with this kind of a legislation which ultimately is going to do far more harm than actual kind of advantage. And also, for the first time, you talk of a pecuniary fine of 500 crores per incident, but the fine is going to go back to the state. What kind of effective remedies would individuals have? Under the IT Act, under 43A, you could still ask for unlimited damages by way of compensation, but now it's pecuniary fine by its intrinsic nature, will have to go back to the exchequer. So is this nothing but a mechanism for the government to enrich its exchequer, or coming up with a new revenue stream? And the Damocles sword of 500 crores is good enough for some of the biggest companies in the world to really start thinking again. So a lot of issues that are being raised. Hopefully those issues will be addressed as the government looks at it.
Thank you, Dr. Duggal. And I think the world is looking at us as we go ahead with this law. Of course, it would not be read in the rooms in this country, but also to all the investee companies in India, people who have long-term commitments to this country, they would also look at this from a point of concern. Now, in the interest of brevity and less time that we have 11 minutes to go. I'm going to club 2 questions and about 1.5 minutes each if you could give your inputs. Question number 2 being that the citizens' rights to privacy in the 22 Data Protection Bill. How and to what extent would businesses be allowed to access and store our data? A comment on that, the rights that the businesses have. Secondly, it is what Apar spoke about in his first answer. The question is about the brevity of this whole bill, 30 sections as compared to 98 in the 2019 Data Protection Bill. And of course, the may prescribe point that precedes. What concerns does this raise to my panelists? I will start with Manjaree.
Let me try and see if I can your second question first. Yes. I think it does, yes. I think it's not, everyone knows this now by the time we've finished reading the bill, that yes, there is a lot left to the discretion of the government, and as may be prescribed. That has very wide connotations, and in certain instances one can appreciate and understand from a government standpoint where it has to deal with the sovereignty and integrity of the country, where it deals with the security, where it deals with large public interest. But I think you know, you have to be very careful, like we just earlier talked about, that it's bereft of details. So the detailing needs to be there for a common person reading it to get that kind of comfort. Be it the Data Protection Board, we don't see any kind of, there's no laid down composition. They cannot make subordinate legislation. It would be as prescribed by the, as you know, set out by the government. They will nominate the people. There already have been issues raised around the so-called independence of the board. Is it going to be just a titular body, or is it going to have effective teeth like you see the CCI and other such authorities? That is going to be another point. Then I think the whole thing about localization of data and where it could be, you know, if it can be stored in servers outside of the country, then those countries will be as notified by the government again. So, you know, I wish they would have done something, even if they had to keep that, it would be something more like create a negative list that you're allowed to send out otherwise, but other than the countries which are in the negative list. So nothing of that kind has been laid down. It is absolutely to the discretion of the government. So I particularly think that the government has tried to keep it. Now if you look at it purely from a government standpoint, which sometimes you are first constrained to think when you are trying to read a legislation to see what may have prompted them to do this. I think a lot is going to be done in terms of the rules that are going to come out. I think they wanted to get, it's very important for the country to have a legislation, given that we are working only on data. They needed to get that out quickly, but I think they also are looking in some manner that there may not be too many issues around it. Let's get this over and let's get the rules in. And the rules therefore can be subject to amendment and repeal. You know, often you can keep on shuffling around with them. So if there are comments there, then you know they can probably be addressed there. So I think yes, no detailing, lot of issues, some good, some not very good. Lot of them are such where we don't understand what we need to do. I think that needs to be detailed and given more comfort to the citizens, basically.
Thank you, Manjaree. We'll go to Karnika for her comment.
Okay, regarding your second question, I just have a comment to make. What data the entities are collating from the citizens, they have to give very, very clearly in terms of our policy, terms of use policy and privacy policy, and what data is going to be collected. It has to be itemized, and the consent has to be express. Then whatever data has to be stored, it has to be retained for a particular purpose, only for a legal purpose and use. How it is going to be transferred, if at all shared or disclosed to some third party, is also to be given very clearly in the policy. And the consent for that as well needs to be taken. So it's not something ambiguous that one you take a consent one day and the next day you are sending data to somebody else for processing. It has to be very, very clearly put out in the first place. So these are the kind of aspects which have been addressed even in the new bill. And for how long the data will be kept, already the government has laid certain policy and certain measures like 180 days retention time. And there are various laws which go alongside, but for this particular bill, there has to be complete transparency in what you're taking from the people and for how long you'll be keeping and where you'll be keeping, or if you're disclosing it to somebody for what purpose. Then the third question, yes, when it comes to state power, the central government has the power to make rules under the Act and in number of aspects, including the appointment of the members of the Data Protection Board, as well as the aspects of when you say any kind of surveillance. Even under the IT Act we have certain provisions, but those are those kind of issues where, for example, their public order is at stake, or the security of the state is at stake. Those kind of very serious concerns, the state naturally has to have powers to look into certain situations. But at the same time, I would go with the PUCL judgment, also the Justice K.S. Puttaswamy judgment, which have very clear guidelines on how we need to exercise that power. It cannot be something which has no basis. there has to be a reasonable suspicion, there has to be a, why a particular interception also occurs, or why a particular data is being looked into, and for how long it is being kept. Retention without any need or cause is something that definitely concerns any lawyers. I would say any experts would be looking into that aspect. I also second that. However, on a broad spectrum, the powers which have been reserved by the government, they have been reserved, but have to be, when the law, like even if it's a subordinate legislation which comes along, it has to stand the test of rule of law. It cannot be unbridled power. Right? So that we all understand and appreciate, and there have been lots of important judgments to indicate how this power has to be exercised and in what parameters. So keeping those parameters, public interest, then that has to be defined as well. It cannot be something ambiguous. We all understand those things, but those principles have to be abided by. It cannot be something which one does, keep it as in a void, and any kind of rules would be brought into play and they will function. That doesn't happen. We all understand.
Thanks for explaining that. I'll go to Apar Gupta for his final comment.
Tarun, you asked two things. The first is that how will it apply to the private sector? And I think some amount of comment has already been provided. I'll just add one aspect, which is on exemptions, which was not there earlier. Now, the law under Section 18 can now also exempt individual companies from the application or a class of companies, and this is the criteria. The central government may by notification, which means directly by issuing a notification, which means the Ministry of Electronics and IT will issue a notification, having regard to the volume, which means it may be high volume or low volume of data, which can be basically 2 TB or 200 TB. So that's not defined. And nature of personal data. Again, the nature is not defined. It can be sensitive, it can be ordinary, right? So the values are not prescribed, minus or positive. So I'll read it again. The central government may by notification, having regard to the volume and nature of personal data processed, notify certain data fiduciaries or class of data fiduciaries as a data fiduciary to whom the provisions of Section 6, subsections 2 and 6 of Section 9, Sections 10, 11, 12 of this Act shall not apply. And if you read it, these sections are basically the sections which offer user rights, notice, consent, etc., retention. Okay? So the government, under what is fairly undefined criteria, can notify an individual company, and I'll leave your imagination to do the rest. The second thing is, when we see rule-making power by the government, it's usually exercised by a nodal ministry, which under the business of allocation rules has certain topics allocated to it. And this is the Ministry of Electronics and IT. And I don't mean it from a point of them acting in malice. I mean it from a point of their administrative capacity. Over the past 4 years, under the union budget, the Ministry of Electronics and IT's budgetary allocations are stagnant. So while teleconnectivity and digitization has become more important, it is getting the same amount of money, which means it has the same number of people, which means it will be administrating this law directly rather than a regulatory body, which was under the Shri Krishna draft. And if you look at the Shri Krishna draft, every draft legislation also has a financial memorandum that a regulatory authority will get so many crores of money, land, basically this is a techno-legal office, so which also means that they won't have a physical office, right? And it's not a regulatory body. So the enforcement itself will be spotty for companies in the sense that it will be inconsistent, it won't be clear, bright line, and it won't be done properly. So I ask myself, what will this law achieve in the long term by itself? And it may not be the objectives which is set out in the case Puttaswamy judgment. Now let me not be only negative, right? What can we do and what can we do better? But this is very unlikely. I think we can go back to the JPC draft, and it is a draft which has developed with 3 years of work by the central government, by an expert committee, and by parliamentarians cutting across party lines, and we can work on it, right? It's been so much work we've put into it, and I think that will benefit us more, both as citizens as well as in the corporate sector, rather than a law which is vague and as may be prescribed.
Over to you, Rajul.
Thanks, Tarun. To your first question, Tarun, regarding what can businesses do now, data localization and transfer of data. That was an important topic that was covered in 2019, obviously coming from the recommendations of the body that was constituted for this. Now, what it basically says is that cross-border transfer of data is actually not prohibited. You can, so all these companies who are collecting data can transfer this data outside the country, and there is no category of data. So earlier we had this whole category of sensitive data, non-sensitive personal data, and then there were different restrictions applying to them in terms of transfer. Now, since all that categorization is gone, there's just one concept called personal data, and all that data can be actually transferred to any country outside India, which will be to the whims and fancies of the government, depending on them, who they want those to be those economies where the data can go. So basically, companies can transfer data outside the country without your knowledge. Forget about consent. That is a biggish power, I feel, that has been given to the big data companies. When I actually answer the question, which is the second question that you asked, Tarun, with respect to the rule-making powers. Now, I'm actually surprised. When I saw the bill, it looked like it's a law to make laws, rather than a law in itself, right? And which is why it is a bit shocking for us as citizens that the basic right to privacy that I have, which the Supreme Court recognized in 2017, very flatly saying that there can be only exceptions based on necessity, legality. When I see almost all sections have an exception and there is a carve-out for government to carve out anything that they want out of that. So without there being any guidance, like for example, when we see deemed consent requirements, when we see storage requirements, so government can exempt companies from the storage requirements, which means that even after the purpose for which you had collected the data is over, you can continue to retain that. And government agencies, by the way, are already exempted from this. So it's shocking to see that the entity, the legislature which will discuss this bill, will actually leave, I mean, if it passes in this shape, then basically everything will be legislated by the rule-making bodies. And that is something that is, I mean, that's a big harm that I see to the citizens and to the country, at least in its current shape and form.
Thank you, Rajul. And looking at Dr. Pavan Duggal, I'm reminded of an anecdote that is true for any of the 5th panelists that I ever have, that his predicament is of that of the 8th husband of Elizabeth Taylor, which is, I know what to do, but I don't know how to make it interesting. But I think you will still, please.
Thanks. I think I'm concerned more about the conflict between the IT Act and the proposed data protection law, because in the current form, there are huge collusion courses that I see on the course. I see huge conflicts, and if those conflicts are not going to be resolved, there are going to be huge problems. Intrinsically, the entire concepts of data processors, data fiduciaries have not been mapped up in the context of intermediaries per se. And that being so, there is a problem. The IT Act is a special law. This new law says I'm also going to be special law vis-a-vis data, which means anything on data, IT Act is deemed to be quiet or overruled. Now it will be a rule of harmonious construction that will have to be resorted to by the judiciary, but I see a lot of litigation happening right away. So a lot of work for lawyers, but ultimately I'm also slightly disappointed at the lack of criminal elements incorporated under this new law. Ultimately, data is now the new oil of the new economy, and data becomes a kind of an ammunition both for committing cybercrime and also for targeting of cybercriminal activities. But those aspects have been left untouched in the new bill. So let's wait and watch how things happen. But all said and done, it's an interesting move forward. I hope all these suggestions that the various experts are giving would be taken into consideration. But it's always great that let's not act in a hurry and repent at leisure. Remember, we are already late to the party. So even if we are late by another few months, that would not really necessarily be of much significance, considering that we are going to be dealing with the data of 1.3 billion people, and the world at large is going to look up to India as to how it's going to do it. And this law is going to come up during the time of India's presidency of the G20. So all said and done, historical moment, but also a great moment to seize opportunity and do some real concrete benefit for all data stakeholders. Thanks.
Thank you so much, Dr. Duggal.